Hello, and thank you for taking the time to look at the Jones Health Law YouTube page. My name is Jamaal Jones, and I'm the principal attorney for Jones Health Law. And periodically, we like to post different videos addressing different issues that may arise for our healthcare providers. We're a full service health law firm and a business law firm in Miami, specifically Coconut Grove, where we service the entire South Florida area. Today, I would like to discuss what to look for when negotiating physician employment agreements. This is something that's going to come up in every physician's career, and it's something that really should be paid careful attention to. So, physicians employed by hospitals, group practices, or any other type of healthcare facility usually enter into a business relationship by signing a physician employment agreement unless the physician is an independent contractor. At Jones Health Law, we instruct all of our physician clients to carefully review their physician employment agreement prior to signing. You want to be sure that you know what you're signing because there are a lot of terms and conditions that can be varied within the agreement that you might not see or you don't understand. Many physicians believe incorrectly that they cannot negotiate a contract. This is not true. Every section of the contract can be negotiated by your attorney. If you don't approve of some of the terms contained in the agreement, you have the power to ask your prospective employer to change that provision or those provisions so that it better suits you and your needs. Of course, the prospective employer may be unwilling to revise some of the terms of the contract, and at that point, you have a very important decision to make. You have to decide whether these terms are deal breakers or not. Only you can decide whether you're going to take it or leave it. There's no secret that there's a shortage of physicians, and it's even more difficult to find physicians adequately suited and licensed in certain specialties. Use that to your advantage when entering the negotiation process. Younger physicians may have more difficulty with negotiating contracts, but it's not impossible. You want to place yourself in the best situation possible, even if it means walking away from a prospective employer. Physicians must realize that while working for a specific healthcare facility may initially be a dream job to them, it can turn into a nightmare later on because of the terms contained in your physician employment agreement. Terms of the contract can pose limitations on the physician for several years after their employment with that particular employer has concluded or expired or has been terminated for any reason. Some physicians don't bother to read the contract or the agreement thoroughly if the financial incentives are very appealing. Yes, making $175,000 a year is a great salary, but there are a few things to consider that might not make that salary look so good after all. So I'm just going to go into a few sections of a physician employment agreement that I recently saw and raised some red flags for me. Now, this isn't an exhaustive list, but just a few that I've picked out. So the first section or clause that I'll go over is what we call a restrictive period and geographic location clause. Physician employment agreements usually have a covenant not to compete clause that imposes limitations in certain actions that the physician can or cannot engage in. Many times, the time and geographic restrictions are very lengthy and far-reaching. For example, a physician employment agreement may state that you cannot solicit for current and past referral sources or own, manage, operate, control, or be employed by a medical practice or healthcare provider for a period of 3 years within 10 miles of any of our locations. This becomes problematic if the employer has offices in every county in South Florida. You may have to end up seeking employment in Monroe County or moving to Pinellas County or Orange County. because of the restrictive geographic location contained in your employment agreement. So that's something that you really want to try to negotiate and minimize the duration and the distance for the time and geographic restrictions. The next clause is transparency of care. Many practices require that you follow the practice guidelines and company policies, but don't specifically identify any actions that can be taken against you or the procedure that follows if any of those guidelines and policies are violated. This is something that you really want to get more insight about and to have your employer make it more clear if possible and if they're willing to do so. Because otherwise, this is very vague. You're not able to discern what type of action your employer can take against you in the event that you violate one of the practice guidelines. Many smaller practices don't really have what type of action is going to be taken against you if it's a smaller practice. Larger hospitals tend to have that. So it may not be such an issue there, but for smaller group practices, independent practices, this is something that should be of some concern to you, just so you have an idea of what's to come. The next clause I'm going to discuss is performance evaluations. Negative performance evaluations may become a part of your employment record and may be used against you at subsequent peer review hearings, during litigation, or during future contract negotiations. You want to determine who will be conducting the performance evaluations and whether that party will do so in a neutral and objective manner. This is very important because these evaluations can give rise to for-cause termination, which may negate your employer's requirement to compensate you in accordance with the contract. Also, if you were to fail their performance evaluations, you want to determine what its effect is and what recourse can be taken against you by your employer. For example, would they require mandatory education courses? Can they terminate you or would they terminate you? Would you be suspended for a period of time? Those are some of the nuances of this that you really want to try to understand and have it mapped out and in writing if possible. The next clause that I'd like to address in the physician employment agreement would be the conflicts, confidentiality, and non-disclosure clause. Sometimes this is broken up, but I've just decided to couple them all together for purposes of this video. These paragraphs, or this clause, is usually drafted very broadly, and in many cases they're too broad. For example, language in this section may preclude you from engaging in any type of business activity that could potentially interfere with the business of your employer. The employer may require that you obtain express written consent from them prior to engaging in any other type of business activity. This means that if your wife wants to open a dance studio and you want to be a co-owner, you would first have to seek employer approval from your employer. Failure to do so might result in a breach of contract. Typically, the employer grants herself a lot of authority in this section, and it will remain that way unless you negotiate a change. The next clause I'd like to discuss is the covenant not to solicit employees of the employer. So I'll start by giving you an example. Common language that you see in this section or this clause would be, you may not directly or indirectly, orally or in writing solicit any employee or employer, to work for another healthcare provider rendering the same or similar services of the employer. This is one clause that causes a lot of physicians problems because they don't realize that stealing an employee from a former employer may be actionable in court. Additionally, this clause as written is broad and means that you cannot place advertisements in any form of media while looking for employees of your practice if the employees of the employer could potentially see it. If you do so and the employee is hired by your company, you may have to pay the employer thousands of dollars for each violation. The reason for this is because an advertisement may be viewed as an indirect written solicitation, even if the employee wasn't targeted specifically. The next clause that I would like to discuss is the effects of termination. And for me, this is arguably the most costly section of any physician employment agreement. I've seen agreements that state that if a physician terminates the employment agreement prior to its natural expiration, the physician will be responsible for paying the employer 6 months of their base salary. So, in other words, if you choose to resign from your employment with this healthcare facility and you're earning $150,000 in base salary, you would be required to pay your employer a whopping $75,000. That is what you agree to in your physician employment agreement. So that is something that you definitely want to negotiate. You may want to negotiate it down to 3 months or 1 month or whatever you feel comfortable with. A lot of times they also stipulate in the agreement that that payment or payments towards that 6 month base salary return essentially would come out of your final check, which means that you wouldn't receive a final check, presumably. So again, a term that you really, really want to review thoroughly. The next clause would be the continuation of contract. Many employers require advance notice that you don't intend to extend the current employment contract for another term period. Some employers require as much as 6 months written notice before the expiration of the agreement. Failure to do so may be actionable and they might seek damages. I advise my clients to reduce the requirement to 3 months notice at the most, because business opportunities may present themselves to you within that 6 month window and you don't want to be precluded from doing so, and miss out on an otherwise wonderful opportunity for you. Now, the final clause that I'm going to discuss in this video would be the employer may assign agreement. Businesses are bought and sold all of the time, and medical practices are no different. Many agreements state that the employment agreement will belong to the new owner, and you're bound by the terms of the agreement during the remaining term period. I tell my physicians to negotiate this clause so that they have the option to terminate this employment agreement without triggering the effect of termination clause that I referenced earlier in this video, should the employer choose to assign its interest to a successor. Look, let's face it, your employer might sell their practice to a new employer that you may not want to work for any host of reasons. You don't like their business practices, the way they market and advertise. You've had a bad experience with a chief medical officer or other colleagues in the practice, or whatever the case may be. So you want to be sure that in the event that something like this does happen, that you can terminate the contract and not trigger, let's say, that 6 month base salary that's owed to the practice. These are just a few of the problematic clauses that I typically encounter in physician employment agreements, but this is by no means an exhaustive list, as I said earlier. The terms in this employment agreements vary from one employer to the next. I strongly advise you to contact Jones Health Law so that an experienced healthcare attorney can review the contract and negotiate it on your behalf. Again, I'd like to thank you for taking the time to look at this YouTube video. We have several other videos addressing various topics that may appeal to you. So I'd say take a look at some of the other videos on the channel. And if you have any questions or comments, you'd like further information, please don't hesitate to contact me. My email address is jrj@joneshealthlaw.com. Our office number is 305-877-5054. Our website is joneshealthlaw.com. You can find us on Instagram at joneshealthlaw. You can even add me personally on LinkedIn. Just look for Jamaal Jones, or Google Plus, Jones Health Law. So again, thank you for taking the time to look at our YouTube video.